All right, everybody, welcome to the Creative Finance Collective. This is our weekly opportunity when we have participation to talk about all things creative finance. Right now, we just have Sean and I here to discuss creative finance. So if you have a question, here's what we're going to do today. We're just coming off a holiday. So as you can predict, a lot of the folks that might normally be on here are either on vacation or traveling or still have work off or just catching up on work. So it's hard to get participation on a day like this. But we're here to take any questions that you have. We'll be here for the hour if you have questions. If you don't have questions, Sean and I have ample opportunity to talk with each other on any other day of the week, and we do it all the time, so we don't need to do it live for you. But we're happy to do it for a while if you have questions, to take any creative finance questions. So if you got them, post them. We'll be on here for a few minutes to take any, and we'll see how far that goes. Otherwise, we don't have any other guests to discuss details with. While we see if we have any questions, Sean, I watched my alma mater, Liberty University, play in the Fiesta Bowl, and it was a little embarrassing. Although I had a feeling going into it, they weren't going to be able to take on Oregon. That was kind of my gut.
Yeah, they were definitely overmatched. But credit to Oregon, they could have ended up with all those other schools that had, players who chose not to play. I mean, they had their star quarterback there and pretty much a full roster. And, you know, um, at least Liberty made it there. They were undefeated, right? So, yeah, it's pretty cool for a small school to go that far anyway.
And they look good on the first drive. I watched the beginning
Man,
of the game, the first drive. I was like, wow,
yeah.
this could be a game. And it quickly unraveled. So
Yeah, and then they held Oregon to that field goal, and you thought, "Oh, wow, if, they score again, like, this could be interesting," but no. They were definitely overmatched, but looks like we have a question, from Walter here, and the question is, in fact, we were talking about this earlier today, on the In Rim podcast with Larry West. He says, "Is depreciation the reason people buy at the end of the year?" And the answer is, it's my understanding that investors generally want to close on their transactions by the end of the year to claim depreciation. But that's probably a question that's better left to the Larry Wests and CPAs of this world to, answer and explain exactly how depreciation works from a tax perspective. But yes, that is a major tax benefit to investors and why a lot of times they want to close by the end of the year.
now we do and assist with some creative finance closings. And I know you spend in our office the most time assisting with creative finance closings. Were you seeing an influx of closings towards the end of the year?
Not too much. I mean, we tried to get the ones that were in a position to close, but there are, unfortunately some that just, you know, weren't in a position to be able to close it. And so, but there is no mad rush. What is and causes a depreciation recapture? Walter again posted. That's something you'll want to talk to a CPA about. I don't even want to try to go down that road. Larry West was on our show today. I would definitely reach out to him. He's out of Texas. Or there's local attorneys here in Arizona or in not attorneys, CPAs in, Arizona or your state that I would definitely contact and discuss the depreciation recapture and all things depreciation and tax for real estate investing.
Yeah, good question. Which illustrates the need for a good tax professional. I know that we as real estate attorneys will get questions from that always implicate high end or sophisticated tax type questions and those kind of things. And sometimes we know enough to get ourselves in trouble, but not enough to give advice on it because we're not tax attorneys. But good question. I'll go ahead and read this one to you. But Walter, again, is it an IRS rule that you need to use the current market interest rate? when lending money?
So the little bit that I know, once again, we're getting a lot of tax
Yeah.
questions. Once again, reach out to a CPA, tax attorney, enrolled agent, to ask these questions. But there's a loan is not invalidated by not charging interest, but the IRS has a imputed interest amount that they'll impute to avoid gifting in as in disguise as a loan. And so it's not the fair market rate, it's some other rate that the IRS uses to impute interest. So let's say, Andy, I loan you $100,000 at 0% interest. The IRS could come back and say, oh, no. Andy, even though the loan doesn't require him to pay you interest, and even though legally he's not required to pay you interest, we're going to go, and Sean, you're going to be deemed to be taxed on a certain percentage of interest on the payments that you receive from him, which basically means I end up with a taxable event with no offsetting revenue to account for it. So there's an imputed interest, which is why, there's, in the subject to world, you talk about, 0% versus some, level of interest that's being charged or paid as part of a creative finance or seller carryback transaction. Because otherwise the seller potentially could get hit with basically a phantom tax.
Mm-hmm. Yeah, I think I don't know if this is where you would most often see it, but you hear about, or I've seen estate planning situations where the reason they do this is to stop me, let's just say I've built my empire and I'm worth millions of dollars and I want to, before I die, give my kids $1 million each, but I don't want to pay the gift tax. So we just call it a
Right.
loan, right? And they're like, well, okay, well,
Loan.
that's not a
Right.
loan.
Yeah.
That looks a lot like
Right.
a gift to us, and
Exactly.
we're gonna tax it as a gift.
Right.
So, I do think the circumstances of that are different. There could be probably, I would think, commercial purposes potentially for a loan that you do expect to be paid back, and you don't get a gift, but, if you're not wanting or for whatever reason to bargain around, an interest rate. Um Another question from, Walter. How do you get insurance for a house under sub 2? Are bigger insurance corporations friendly to sub 2? Now, I know this topic comes up a good bit when we discuss with guys like Alan Seshker and things, how to properly insure
Right.
the transactions. What are your thoughts there?
Yeah. So for insurance purposes, the proper way, or there's two schools of thought. And so I'll give you both of them. One school of thought is, I'm scared of the due on sale clause. I'm scared of submitting insurance documentation to the lender showing that, I'm now the buyer of the house and that the lender is going to invoke the due on sale clause now. And so we just leave the seller's policy in place. Don't mess with it. Just keep paying it. And then from there, we go and I, as the buyer, go and obtain my own policy. The property. So that's one option. The second option is to, and the one,
Sean, I think we lost some of your sound. Oh, now you came back, I
our folks
think.
over to, all right, we refer, so another school of thought is, and the one that Alan Sesker talks about in his rap university, and as well as an insurance agent that's very experienced in subject to, subscribes to out of Texas, who, you know, we've referred clients over to him. He can write in Arizona, is to list the buyer as the insured, the seller as an additional interest, and the lender as a loss payee, and then submit that to the lender. And from there, of the transaction, they have their own loan, right? They have their own mortgage in addition to the subject to component. Then you would list the seller, and the seller's loan documents are going to say that the seller should be listed as a loss payee under the policy as well. But nevertheless, you submit that to the lender, and then the lender should accept it. As far as are the bigger insurance corporations friendly to subto? Probably not. I mean, I think you're going to have to go with a smaller insurance company and use an insurance agent that can, you know, write the policy, that knows how to write it. And that's what I would recommend. I'm not sure I would go to some of the bigger insurance companies and try to, you know, work with their agents to figure out, you know, their captive agents on how to get this.
Yeah, I was gonna just jump onto that, Sean, that it's less of a question about the bigger insurance agency or companies versus the smaller. It's more important to get the right agent. What was the name of the agent out of Texas that does all the sub-twos? Do you recall?
Mike Monzingo.
Oh,
Mike
Mike Monzingo.
Monzingo.
Yeah, in fact, we have a whole in the Interim podcast, an entire episode with Mike Monzingo about that. And but he's out of Texas, and he's a good one to reach out for. But a lot of it is about a lot of it really is about working with the right kind of professional to make sure that they get it right on that one. Another question: do you get a power of attorney for every sub-2 transaction? I think. Go ahead,
Yes, you
Sean. But I
do.
think, yeah, the answer is yes. I can't think of a transaction where you wouldn't want to do that. You could do it right, but the problems with not having it are the bigger issue.
So, couple of things. Where you wouldn't want to do it is on a disposition, right? So, because on a disposition, the buyer, well, the two places you wouldn't want to do the power of attorney. So, would be if you are acquiring the property subject to, but the seller is basically doing a carryback. So, let's say that the subject to loan is $300,000 at 3%. And the seller is going to sell the property to you at $500,000, but they want 5% interest, and they want a $500,000 loan at 5%. In that case, you're probably not going to do a power of attorney, because that seller's going to, you're going to put a servicer in place, and that seller is going to be responsible. The seller and the servicer will be responsible for making the mortgage payment. The taxes and insurance will be dealt with as part of the new loan payment that you're going to make to the seller. Basically, the seller is now a full, you know, lender in the middle of the existing lender and you as the buyer. So you probably are not going to do a power of attorney in that situation. Or if you sell it, if you do a disposition, which is going to be something similar to what I just described, where you say, okay, the existing loan's 300,000. I'm going to sell you the property for 500. It's going to be 5-6% interest, and we'll put a servicer in place, and then I'll make sure that the mortgage payment is paid. In that case, you probably aren't doing a power of attorney either. Yeah. And then we have a Facebook user saying Mike is awesome. They've heard of him. And now he's actually helping their TC clients. So yeah, definitely reach out to Mike Monzingo for your insurance needs. He's a friend of the show. He's been on our podcast before. Great guy and a great asset to the Subto community.
Yeah, he really is. All right, we have another question. Why are people putting profits into their own charity fund, then to their own life insurance? Is this common?
I don't know.
I have no
That's
idea.
something you want to talk to a high-end estate planning attorney, talk to a CPA, talk to an insurance, not an insurance, a financial planner, and come up with a tax strategy. Larry West, once again, was on our show today. He can probably go over that strategy and let you know why people are doing what they're doing on that end. We're not, we, like Andy said, we know enough about tax to kind of be dangerous, but um, we're not tax attorneys, CPAs. We know the real estate side of this transaction, but we do not get involved in the tax planning side.
Yeah, that sounds like a pretty high level strategy. Definitely talk to a CPA. If you're just now joining us, this is the Creative Finance Collective. We're taking questions about all things creative finance. So if you've got questions, make sure to post them. A number of our common participants are out on vacation. It's that time of year. People are still coming back. So Sean and I are here for as long as people have questions. So if you have a question, make sure to post it. Normally we're here through the hour. Otherwise, we're here until the questions end. Sean, did you see? I know mortgage rates. They hit their high, and they've ticked back a little bit. They're still higher than what people would like. In other words, I think they ticked back down into the 6% range or whatever. But have you seen any sort of slowdown in creative finance transactions in the last month or a couple months?
No, if anything, I've seen an uptick in those, but yeah, no, we've not seen any slowdown whatsoever. But to Walter's point about closing at the end of the year, you know, I'm coming off my busy season, which is generally the three weeks or so after Thanksgiving, tend to be my busiest all year. And so, everyone kind of puts off their transactions, puts off their restructuring, but then they want it done by the end of the year, which really means they want it done by Christmas. So, um,
And
so it was pretty busy there for me.
I don't get the sense, though, that investors are changing their strategy. We're still living in a higher interest rate environment, with lots of sub 4% loans sitting out there. And it's
Right.
still a popular strategy, and I think is gonna be one that's gonna continue. You're hearing hints about the possibility of the Fed cutting rates coming into 2024. They haven't done it, and even if they do that, it would be incremental. I still see it as it being a popular strategy for some time. We have some more questions here.
Uh, Yeah. So Munif commented here.
Mhm,
He who Munif is a um, an experienced investor, does a lot of transactions, high volume, and he is commenting that he's personally seen a slowdown in wholesaling.
mhm.
Buyers just aren't buying creative deals like they used to. It's gotten much harder to sell creative deals sub two, and that could be true. You know that well, it is. I mean, I'm not a wholesaler, so I'll take Munif's word for it. It is apparently harder, especially on the wholesale side, to find end buyers. Um, and so, yeah, maybe there is a little bit of a slowdown going on.
Yeah. We have another question from Walter. Is there any books you guys recommend reading to get to know the paperwork side of real estate better? What do you think,
I don't know
Sean?
about the paperwork side. I mean, Pace Morby has a book. I think it's called Wealth Without Cash or something like that. I think Mark Monroe, who's been on the show before, has a book out there on creative financing. So both of those I think can be picked up off of Amazon or
Right.
other locations, but I don't know how in depth they go as far as the paperwork side of the transaction. My recommendation is to know what paperwork you need. Hire an attorney in whatever state you're doing your transactions in, whatever state you reside in, and basically say, hey, look, I'm going to be doing this transaction, and find an attorney that's knowledgeable on subject to. And part of the collective is having these attorneys that are involved. So
There's also
you know,
Rap
happy to
University,
give
right?
referrals too. Yeah. Oh, that's actually a really good one. So Alan Seschker has Rap University both in person and online, and he actually hands out forms. In fact, Andy flashed the QR code up there for those that want it. You know, click on that, and you can attend Rap University, and he offers a lot of the forms and goes through the forms that you need. I attended Rap University, and it was awesome. I would recommend it for anybody,
Yeah,
whether you're investing in Texas or otherwise. Now, part of it is state specific, but part of it is just general. So it would be great.
Yeah, so we've got the QR code up there. So if you've not watched us before, in fact, Alan Seschker, who puts on Rap University, was going to be on with us today, but couldn't make it. He's on a lot of them, but he does the Rap University, and you just scan that QR code, and that will take you right to him. I'll just leave that up there. Yeah, you're right. I know that
Yeah.
Pace Morby, Mark Monroe both have books. I can't think of any other books on creative finance that I'd recommend. I think the Rap University and things like that, where you're hearing from a lawyer on how to set up the forms, because there's different folks will tell you different ways to do it. Not everybody likes to do it in what's called a wrap, right? But we think it's the best way to go about doing it. And Alan certainly thinks it's really probably the best and fairest way to go about setting up that transaction.
Oh yeah, he's a huge fan of wraps, but he has to be, because Texas doesn't allow agreements for sale or contracts for deed, nor do they allow lease options. So he kind of is stuck with the wrap. But there's other methods, contract for deed, agreement for sale, which are the same, just depending on what state you're in. And then there's lease with option to purchase. So those are other structures that are good, and can be utilized.
Yeah, we have a Facebook user says Alan Seschker is great. He handles all of their Texas subto files. Makes a lot of sense. He's really one of the go-to guys in Texas, along with Scott Horn in Texas. They're who we rely on pretty heavily to get Texas information. So yeah, you're making a good decision to go work through them and do that. And like Sean said, you don't have to be from Texas to take the Rap University. Look, I mean, if you're going to get into this as an investor, you need to understand it from the document side of things and why that's done. We do wraps here. We structure these agreements in the form of wraps for various reasons, and you need to understand what that is, what that looks like. If you're just now joining us, this is the Creative Finance Collective. We are taking questions throughout the hour or until the questions end. Normally, we have other attorneys from various states, but a lot of them are traveling right now. So Sean and I thought we'd come on and answer any questions that the folks that are here and ready to start the new year have. So we're happy to do that until the questions run out. So it sounded like part of our discussion earlier. Oh, we've got another question. Let's go ahead and go to that. Question from Walter on YouTube. What would happen to the earnest money if the buyer and seller passed away before closing and after the inspection period?
Sounds like a bar exam question.
Walter's a law professor.
Oh man. Oh yeah. All right. So basically, if it's past the inspection, the seller and the seller's estate is bound, and it the buyer's estate. Trying to think. I think the buyer, correct me if I'm wrong, but I think the buyer's estate doesn't have to perform, but I don't know that they get the earnest money back.
Right. They've got basically an election.
I think the earnest money would go to the, yeah, I think the earnest money would go to the seller's estate unless there's a financing contingency or other contingency in place. So the earnest money would go to, likely go to the seller in that scenario, or the seller's estate. Do you agree? Disagree?
Yeah, I don't disagree. I'm thinking, what I'm thinking about is, what would the buyer have to do to elect to continue with the contract, right? You would need the appointment of a personal representative.
They would need to get access to the estate. So do a probate and do a personal representative. The seller would have to have a personal representative, and then you can close. But basically, I believe the buyer's estate has the election to either cancel and walk away from the earnest money, or to actually come up with the cash and close on the transaction.
Yeah. We have a couple more comments. One Facebook user thought that question was funny, and it was. We need to maybe we need to pay Walter to feed us questions. He's got complex and good questions. Thank you, Walter.
Yeah, they're good.
Yeah, another question from a Facebook user. Have you noticed a statistically significant reduction in due on sale clause enforcement by lenders when purchasing subto via land trust versus an LLC? So is a land trust any better than an LLC? Have you noticed any different?
I don't do much with land trusts. And in Arizona, it's not even really a thing. So I would not be the one to get involved on a due on sale for land trust. So statistically, I really don't have a good answer, just because, Arizona really we don't do land trusts, for different reasons. One is there's no anonymity with them. So with that said, the whole purpose of doing a land trust is to, hopefully avoid a due on sale clause. But I can't answer whether or not we've, seen any uptick. I will say statistically, we've not seen any uptick in due on sale clauses being called against LLCs. It's nothing's changed. It's still a very small percentage of due on sale clauses being called. And so, with that said, I'm not a good one to ask for the comparison, just because we don't do that.
Yeah, and the only person I've even heard mention it being an issue recently, Alan Seschker out of Texas had mentioned having concerns about, or considering doing things in land trusts over there, basically so that it would look like it's complying with the Garn St. Germain Act. But other folks that we've talked to in Texas have also said I don't think there's any information we would have to be able to measure that. But I mean, here's another question though, Sean. Have you seen the amount of just lenders calling the due on sale clause increase statistically at all? I can't say that we have.
No, I've not seen any. No, we haven't seen any. Now, Alan Seschker reported a few weeks back, or maybe a month or so back, that he's seen a little bit of an uptick, mainly dealing with the insurance, and getting the insurance. But no, I've not seen any uptick at all on the due on sale clause.
Right. Another question. State AZVA loan. In the VA handbook, it states that the VA does not consider contract for deed to be a disposition of property. Does the VA have authority over the loan servicer docs for VA loan?
Um, I mean, look, the VA handbook provides some reliance to the borrower, reliance to the title companies, to the agents, to anybody involved in a transaction where there's been a contract for deed or agreement for sale. And generally, a servicer is going to follow the holder's or insurer's instructions. Can't guarantee it. Technically, the VA due on sale clause mirrors the Fannie Mae Freddie Mac due on sale clause. So technically, and that due on sale clause specifically says a contract for deed is, gives the lender the ability to call the loan due. It says it right there. But we have this VA handbook, which is why title companies will insure those transactions, subject to contracts for deed, agreement for sale. I am not aware of a servicer calling a VA loan due where there's been a contract for deed or agreement for sale, subject to. I've not seen that. So can't guarantee it, but I would feel fairly confident and comfortable that, this is what the handbook says, that this is how they're going to view it.
All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour or until the questions cease. So we're happy to take any questions that you have. Again, we're talking about all things, we'll take real estate questions, obviously, but the focus here is creative financing, the laws, policy, so on and so forth around creative financing. Let's see. We've got another question from Walter. How would you guys approach buying a movie theater subto? Would you change your documents at all,
I mean, I would
Sean?
treat it. Yeah, I would. I would not use a residential purchase contract. I would use a commercial real estate purchase contract. I would, do significant due diligence, the whole thing. But I would, have very similar provisions in the commercial contract that you find in the residential for the subject to loan terms, for the wrap loan terms. I would have, certain acknowledgments so that we know that the seller is fully, comfortable with the transaction, understands the transaction. The thing about buying a commercial property, presumably you have a sophisticated seller as opposed to residential where it's consumer.
Yeah.
So you might not need as many disclosures as you find in the residential, but definitely use a commercial real estate contract. Probably start with a LOI and then move into the commercial contract setting.
Yeah, the first thing you're going to want to look at right away. I mean, there's a lot of due diligence on commercial properties, and we just did an episode. Who was
Correct.
it? Who was it with? Mike Gross, I think, on commercial properties. But I think one of the biggest hiccups to buying sub-2 commercial is when you're buying residential, everything's a 30-year fixed mortgage. Everything. Nothing
Correct.
in a commercial loan is ever amortized over 30 years. So you're dealing with much shorter loans typically, or longer amortized loans, but loans with balloons, right? So
Correct. Yeah. A lot of balloons.
yeah. So that's going to be a big
It can be
factor.
done. It can be done. You just, yeah.
Yeah. So it's going to be a big factor. Like Sean said, it can be done transactionally. It for sure can be done. The question is whether, how long you're getting that nice cheap interest rate for. If you've got a balloon and that's coming due in 2 years, then it might not be worth it. But yeah, then you build out a good bit of due diligence within the purchase contract itself to make sure that there aren't other things you need to know about with the movie theater, because like we were talking about with attorney Mike Gross out of Virginia a couple weeks ago, not only are you buying real estate in commercial, you're buying a business, and in this case, a movie theater, but
Yes.
there's a lot of factors to that.
Yep.
I like that question, though.
Yeah.
What other questions can you guys give us? We're here throughout the hour. If you have any creative finance related questions, um, we'd love to do them. Other than Sean, a commercial question, I guess, a follow up to this. Other than a letter of intent would be different, the purchase contract itself would be different. But I think a lot of the other documents, there's gonna be a lot of similarities to the transaction itself being in the form of a wrap, so on and so forth. Do you see any other differences to some of the ancillary documents?
No, you're still going to have a note, a deed of trust, or a mortgage, depending on what state you're in. Uh, yeah, but the ancillary documents are pretty much going to be the same.
Yeah. We have another question from John. What is the proper way to assign a subto if you do not want to keep so we do not get sued?
Yeah, so an assignment with so number one, the purchase contract should be assignable. And so you have assignment provision in the purchase contract authorizing you to assign it. And then the second would be to have an assignment, and in the assignment disclose to the end buyer the subject to nature of the transaction, right? So you would put in the assignment that, you know, you understand, assignee, that you're acquiring the property subject to existing loans. You understand that there could be a due on sale clause. You understand all of this related to the transaction that you're responsible for, depending on if you're using a servicer or paying directly. You're responsible for paying the seller's mortgage, blah 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 blah. And you basically disclose all that in the assignment, and then from there, I would make my assignment terminate immediately upon the closing date if the end buyer doesn't perform. That way you can come back in, take over the transaction, potentially close, find another assignee, get back into the transaction. But it shouldn't be, hey, assignee, you get all of my rights, and including a 10-day cure notice from the seller, and you can just sit around and not close by the closing date, and I'm stuck here in the middle and can't do anything about it. And I'm going to have an upset seller, but I can't get you out because you have the right to a cure notice, the whole thing. So at the end of the day, you want to make sure that you have a clear closing date, a hard closing date. Close, whatever the case may be.
So we have another question about reverse mortgages. Is a reverse mortgage tied into subto? How does that work? It's not ideal, is it?
No, I mean, because a reverse mortgage is, and because there are no monthly payments on a reverse mortgage. It's reverse. The payments come to you as the borrower. And so I don't recommend subtos on reverse mortgages. Once the person passes away, there's no doubt that the lender is going to call that loan due. And the whole time, it's accruing interest. The loan balance is increasing. I don't know. I don't think it's something that's really doable or should really be considered, unless you think you want it for cash flow purposes for a short period of time, that's something you could think about. But otherwise, it's really not a good investment.
Yeah, it's agreed. It's dicey. Another question from a Facebook user. The new ownership interest disclosure law seems like it's going to blow away our anonymity. Thoughts on how to deal with this?
Come watch the show Tuesday, 10 a.m. The NREM YouTube podcast will be next Tuesday, January 9th at 10 a.m. We will be with attorney Natalia Ouellette-Grice, and we're going to talk about all things Corporate Transparency Act, and we will get into the anonymity features. My answer right now is that's one of the questions we're going to ask Natalia next week to find out what this means. We spoke a little bit about it with Larry West today, and the thought is that this isn't designed really to basically pierce the anonymity public. You and I both know a simple FOIA request gets you that information a lot of times. So the question is, will you be able to request this information from the federal government and find out who, owns an LLC that you may want to sue or something like that? But we'll talk to Natalia, and she probably will have a better answer for this than you and I do right now.
Yeah, for sure. We'll talk to her. She's pretty cued into it. Has been tracking it. And we specifically in a past discussion with her planned an episode just to slice and dice and go through that. So yeah, join us. That's this coming Tuesday. So 1 week from today, if you can't make it live, we'll be taking questions live. So if you can be there to ask questions to Natalia, she'll take them and we'll work through it. Otherwise, you can watch it after the fact. But yeah, we're going to dive into that. Lots of questions about that and the inner workings of that act. And like all legislation, some of it's going to be learned as it plays out a little bit, but we'll see how that goes. If you're just now joining us, it's the Creative Finance Collective. We're taking questions throughout the hour or until we stop receiving questions. So if you had them, go ahead and post them in the chat. We're happy to discuss anything creative finance. Given the comment that we had a little bit earlier about the difficulty of creative finance deals, you think it's that it's harder to find the deals right now or get them done? What do you think's the biggest hurdle to the deals right now?
It seems like it's the wholesaling of a creative finance deal, or finding an end buyer for the creative finance deal is becoming more difficult. Especially wholesaling, because when you're wholesaling, you generally are not going to be wholesaling to a consumer buyer because, well, maybe I shouldn't say that. I'll take that back because it is subto. They don't have to qualify for lending. But yeah, apparently finding the back end buyer is becoming difficult.
Well, do you think that's well, that's interesting because I would think it would be a harder sell to a seller than a buyer, if that makes sense.
Yeah,
but if you're the investor, I think it's
stressed because of the.
Go ahead.
Well, if the seller's in distress because of, inflation and, other financial issues, then they're wanting to unload the property. And if you have somebody that can come in and say, hey, look, we'll catch up your loan, we'll keep it current, we'll pay you maybe a little bit at closing, that sounds pretty good. That's better than a foreclosure and a short sale generally.
Mm-hmm. Interesting. Well, we don't have any other questions, so we don't want to draw it out for those watching. We've had a lot of interaction, had a lot of good questions. Couple reminders coming up. like we said, we're talking about the new corporate disclosure law this Tuesday. Make sure to be there. That'll be a good chance. As we said, we're working through that. And when we've got participation and involvement, we try to hold the Creative Finance Collective every Tuesday at 3 p.m. So make sure to join us each week as we do that. When we get a lot of questions like we had today, we're able to address a lot of stuff. And usually we have a number of other attorneys that can help with that as well. So we don't have any additional questions. So with that, I think we'll call it a week and hit corporate disclosure next week and the Creative Finance. Make sure to join us.
Have a good evening, everyone.
All right. Have a good evening. We'll see you guys